evening. This is June 14th meeting of the Zoning Board of Appeals. First up is a reserved decision. Appeal number 021, 2018. I move the appeal of GO 65 Alfred Avenue, Baiting Hollow, for variance or relief from Chapter 301, Section 37A2 for proposed deer fence 8 feet in height erected in the front yard of a residential lot with maximum permitted height is 4 feet in the front yard. A deer fence 8 feet in height may be erected along the property line as requested with the exception of the following. Deer fencing to be installed 5 feet in height, inclusive of lots 8 to 12. Lot 13 to maintain a 6-foot high fence and a gate 5 feet in height at the crossing of the driveway at a 5-foot fence level shall be installed. Do I hear a motion?
So moved.
Second.
Mr. Barnes?
Aye.
Mrs. Worthington?
Aye.
Mr. Seabrook?
Aye.
And I vote aye. So your appeal has been granted as with the different codicils along with it. Okay? Thank you very much. Go ahead.
Appeal number 2018-019, Brixmore Riverhead Development LLC, 1762 Old Country Road, Riverhead. Tax map number 600-101.1, 1-2, DRC zoning for variances and/or relief from Chapter 301, Section 249E4 for a proposed directory panel not coordinated in color or letter and is therefore not permitted.
Go ahead, just state your name and your address. You've already been sworn in.
Diana Laspisa with Moreno Expediting Services for Hamilton Court, Quorum, New York, 11727.
Okay.
Good evening, Chairman, members of the board. I'm here before you again regarding the application to construct or install tenant panels with the corporate colors and font. We were before you on May 24th, and I believe the board wanted to, I guess, have some internal conversation, so I don't know if there's any comments, additional comments from the board regarding this. I did speak with my client. It's not their intention to withdraw the application. They would be apt to, if the board would consider it, maybe a conditional approval for a period of time, 2 years or something like that. I don't know if that's something that the board would consider.
Have you been to the ARB yet, the Architectural Review Board?
No, because we cannot go before the Architectural Review Board without coming here first. And I'm sure they'll,
Why not?
because that's what I was told, because
Why?
I thought we told you last time to go to the ARB and get a little,
No, I don't think we did.
we didn't tell them? No?
But who's telling you you need to go to us first?
when I filed with the building department, because this was actually a conversation that I had with the building department.
Oh, right, ARB denied it, didn't we? Right.
But we never went to ARB, that's what I don't understand. When we went to ARB, the only applications that were before ARB was the side sign, the front sign, and the under canopy sign. We didn't go to ARB for
The direction.
the directory sign, because we couldn't, it had to be
So-
denied.
Do
Well,
we have a copy of the resolution of the
There
ARB?
is a review sheet for it in the
Okay.
packet.
Let's take a quick look.
I mean, for the record, there have been appeals before you regarding directory signs and colors and logos that we have denied because they weren't to code.
I understand that, I believe one was actually on this same property, I think one was Ulta.
Does not meet code.
I don't know if the board remembers that. I don't have a copy of that decision, I just was told when we filed.
Yeah.
But our standing is that Ulta's, I don't know what other applications you're referring to, but Ulta's a chain that's been on Long Island for years and years. Everybody knows what Ulta is. HomeSense is not known in New York. It's not, actually, the the store, the first store to open on Long Island was May 24th, the day of the last hearing. They opened one store in Comac. So they really, you know, with their advertising, they feel by not having those corporate colors and their signage and font at the street, that it will potentially, you know, impact their business. So that's why maybe a conditional approval, again, if the board seems fit to do that, you know, we would be willing to, down the road, when that approval expires, they'll have to change the signs, and you can send code enforcement out that day.
Yeah, I mean, my opinion is that we have a sign code, and we've made determinations based on that sign code in the past. So I would at least have to see the determination of the ARB regarding
We have it
the
here.
specific appeal.
Okay.
Chance to close it, give it,
But,
let us see it.
They reviewed it, for whatever reason. It might
yeah,
not
I
apply,
don't know
but
why.
They
Uh,
did a
the-
resolution and they denied it.
The secretary, is it Carrie?
Yeah, she's
Carrie, okay, because I don't know if you recall, when I had first filed the application, I had spoken with Sue in the building department and spoken with you, and we thought that we would have to, I thought we would have to come here first. I think you thought we would have to go to ARB first, and then Sue had told me, no, ARB doesn't have jurisdiction until the Board of Appeals either grants it or denies it. So I don't know. And they did make a mention of the directory sign at the meeting, and my staff had stated that that wasn't before them, and I believe somebody else on there said it. I guess they're pretty adamant about being against the application, but it
And
wasn't.
I don't mean to cut you off, but the building department did send the application over to the zoning board. They sent it over with a denial letter, otherwise it couldn't have been reviewed by the zoning board. And the ARB reviewed it, somebody from your company actually came and they went over the application with the architectural review board. That was one of the items that was there, and it was discussed by whichever representative was there.
Yes, it was Rose from my office was there, but I believe, I thought it was clear, you know, she had stated that it shouldn't be before them. I mean, usually can't the zoning board even act on like ARB would be before the building permit and zoning board would be before ARB. I thought that's how it just usually worked.
Well, the
'cause-
ARB in Riverhead is specifically charged with signs. So this is a sign appeal,
Yeah, so,
yeah.
but I guess I thought that the ARB, nobody else, no other departments can review anything until the zoning board makes their decision, because if you deny the application, then it's essentially been a waste of them reviewing it. So that's where I was under the impression, because that's how it usually is. I do
Well,
Nassau and Suffolk, but,
May I ask you a question?
yes.
Did you attend the ARB meeting?
I personally didn't, because I had another hearing that night.
Okay, that's fair. I can only suggest one thing, that right now they're saying, no, they did not approve it. However, you can go back to them and see if you could work something out with them. And if they recommend something to us, it would be amenable to us. We're trying to work with them. So if you're looking for compromise, as you had suggested, I would go back to them first. And we'll get their notes and then we'll reconsider what needs to be done here, if any.
Okay.
That's just a suggestion.
we've been sending everyone back to the, any signs, we're sending them right to them before we make any decisions.
Okay, so if the ARB is essentially in favor, which I doubt they are, they've made it pretty clear, would the board, is that what sways the board? It's really gonna be what ARB?
It's not a
Pretty
de
much?
facto decision, but it's heavily weighed, yes.
Okay.
Yeah,
It definitely heavily weighed,
Okay,
yeah.
but we're open to hearing what your suggestions would be to them and then returning to us.
I mean, that would be our suggestion, the conditional approval. You know, I don't know that they're going, I know the
There's nothing in the statute that allows conditional approval.
No, I understand that, I do understand that, but,
If it was legislated in the statute, I wouldn't have a problem doing that, but it's not allowed to be done either it is or it isn't. They allow for temporary signs, you know, and if your company thinks that they're hurting for business, a temporary sign might be
Well, I guess
the
the
avenue that you
conditional,
may wanna take.
I guess the conditional approval is kind of like a temporary, my what we would like, you know, would be more of a temporary sign if it's only granted for a period of a year. You know, so maybe the word conditional approval isn't
Well,
the best word for it.
You know, we have to take one
I know
step at
that's
a
not
time,
realistic,
and
but
everything's
again, I don't think we have the authority to do that anyway.
kinda like speculation, so why don't we,
I mean, to be honest, I really was under the impression that the ARB could not have could not hold a meeting on the tenant panels without zoning board. If that was the case, I personally would have attended the hearing and not my staff.
They are only advisory, okay? But they voted, and they sent it to us, and they're asking us not to approve it. So, we're asking you to try to compromise with them.
Yeah.
That's all we're asking.
No, that's fine. I guess my point is that
See how it goes.
I would have done that first had I known that that was the
I'm
case,
sorry
but
that you
it's
may
fine.
have been misinformed by certain employees, but
Okay.
it
Now,
is what it is.
once I meet with the ARB, I'm hoping I'm gonna see if we could get on their next meeting. Would whatever recommendations you get from them, do we have to come back before you? Okay,
And I think what we could do is adjourn it. But
For the
let's
next
put,
meeting.
I wouldn't say next meeting.
Well, let's do it for the next meeting, and if there's a problem with that, then we just
do you
adjourn
happen
it.
to know when ARB meets? It's the
They're meeting on June 27th.
June 27th, okay.
So what's your
June
meeting
27th,
following?
so,
The
yeah.
28th sound like it's on Monday.
I'm sorry, what was that?
Our next
June-
meeting's the 28th,
The 28th?
So we'll ask our secretary, who's also their secretary, to try to
Oh, okay.
work it out at that meeting, and then she can advise us through email, and then we can have a decision for you on the 28th.
Okay,
How's that?
that sounds great.
you know, we'll see.
We'll
Thank you.
turn it to
Yeah,
the,
quite well.
well, we said decision, we didn't say positive.
Yeah, Somebody want to move this on to the next meeting?
Mr. Chairman, I make a motion that Appeal 18-19 be adjourned to June 28th.
Second.
Mr. Seabrook.
Aye.
Mr. Barnes.
Aye.
Mrs. Worthington.
Aye.
I vote aye. See you the next meeting. Thanks very much.
Thank you.
Okay.
All right, kiddo.
Percy, do you want these resolutions back?
Yeah.
Thank you.
Next.
Yeah. We have them folded with all that stuff. Okay.
Next is appeal number 2018-022, Overlook Drive LLC, 254 Overlook Drive, Aquabot. Tax map number 600-113-111, RB40 zoning for variances and/or relief from chapter 301, section 17, where the proposed impervious surface coverage is 15.1% of the lot and the maximum permitted is 15%. Proposed front yard setback is 23 feet, where the minimum required is 50 feet. Proposed side yard setbacks are 13 and 15 feet, where the minimum required is 25 feet. And the proposed combined side yard is 28 feet, where the minimum required is 55 feet.
Who wants to get up first? Come on up. You've already been sworn in. Just state your name and your address.
Ed Hocker, 242 Overlook Drive.
You have the floor.
I don't really think I need the floor right now. I presented all the information last time. They have all the information. They wanted 3 weeks to do research, so we'll see what the research brings and what they have to say, and then if I have anything to say, I'll say it.
Sounds good to me.
Ed, may I ask you a question? Have you been approached by anybody about buying the lot from you?
Not since the last hearing.
Not since the last hearing.
Right.
Were you offered anything prior to that hearing?
I didn't hear a number. Michelle said that Tony offered me money. I don't know what the money was. I wasn't ready to accept any money.
Okay, so they
I
said,
mean-
we would like to buy it,
Yes,
and you never heard a dollar amount, and
No.
you wanna move forward.
I
Build
just
a
want
home.
to move forward.
Okay,
I'll worry about that in the future,
yeah,
if there is, you know.
if there is a future,
Yeah, thank you.
okay.
You
Yes.
may. Have you been sworn in before?
I was not, because I'm an attorney and I was told I didn't
And
need
then
to be
you don't have to be
in.
sworn in. Just state your name and your address, please.
Michelle Capitola Johnson, 9 Meadon Drive, Locust Valley, New York. I'd just like to add to the record that post our hearing last time, our attorney, my father's attorney, Chris Coscignano, did provide a number of 200,000. I do believe that was also said at the meeting, I could be mistaken, but a number of 200,000 was offered.
In writing or by
It was
verbal?
a verbal outside after we left,
So he's saying it wasn't, and you're saying it was.
yes.
And you, but were you at the meeting when he
Yes, we
offered that?
all walked out together, and we had a quick discussion, would they be interested? They said, we're not interested at all, but the number was put out there
So.
by Mr. Coscignano, not by
Okay, but
myself.
not your dad.
He was not here, if you remember, he was not here. But on his behalf, that
Fine.
was presented, thank you.
So, knowing that the hearing was gonna be tonight and all this time has passed, you haven't approached them really to make a solid offer, or
Well, I
you just
have
would
not,
rather oppose it, and that's it?
I have not, but that night they made it very clear that they didn't want any offer.
They didn't make that clear to us during the
When we
hearing.
were out in the hallway after we
Okay.
left.
All right,
Thank you.
thank you.
You an attorney?
Good evening. Yes, I'm an attorney.
Kindly state your name and your address.
Sure. Nicholas Capadora from the law firm of Sonward Coscignano. Office is at 333 Earl Ovington Boulevard, Suite 601 in Uniondale. I'm an attorney at the same law firm from Chris Coscignano. We're representing the adjacent property owners. Mr. Capitola and his family are here tonight. They own 257 Overlook Drive, which is probably the most affected premises to the application before you. And I wasn't here at the last meeting, but I was briefed and discussed it with Mr. Coscignano, some of the comments and issues that they had that were put on the record at the last hearing. So what I would like to do is just sort of summarize what was said at the last hearing, and then also go into some of the new issues, some serious issues that we have found that we'd like to put on the record as well, that
Yeah.
need to be addressed. So as you know, we're talking about 250 Overlook Drive. That's the subject premises. It's 9,895 square feet. It's in the Residence B40 zone. So on May 24th, partner Chris Coscignano appeared, and he made some comments and raised some concerns as follows. One of the most important ones was that the denial letter did not address the parcel's lack of street frontage on a mapped roadway, which violates Town Law Section 280A. If you don't have a mapped roadway providing ingress and egress to your buildable lot, then you need to get a waiver or a variance from that section, and that wasn't cited in the code. Perhaps it was an oversight, but it's something that should be addressed and included as part of the relief necessary. Some of the other concerns raised were just generally that it's a substandard lot for the area, which is defined by closer to 40,000 square foot lots, which is what the old, the Cobb Estate, Knob Estate, that all those subdivided lots are plus or minus 40,000 square feet. This lot's less than 10,000 square feet. All of those lots, the four lots of that subdivision I just referenced, were approved without variances and are zoning compliant. So the requested variances here, the substantiality, the number and degree of variances, really isn't in keeping with the area of the community. And upon further review of the town zoning code and some of the other issues raised by, including some of the neighbors, other neighbors that are opposed to this, we have a few other comments and issues we wanted to know for the record. The first one being that, first of all, the three variances that before you right now are the front yard setback variance, where 23 feet is provided, 50 feet's required. So that's already over 50% variance from what the town requires. The side yard setback variance, 13 feet is being provided, 25 feet's required. Again, almost a 50% reduction in what's required. Same thing with the aggregate side yard. They don't meet the aggregate side yard requirements by 49% variance required for that as well. So in addition to those variances, what we found was the lot doesn't come anywhere close to the minimum lot size required for this RB 40 zone, which is 40,000 square feet, which is required. They provide just under 10,000 square feet. We're talking about a 75% variance in the minimum lot size. Also, the minimum lot width in the RB 40 zone, 150 feet is required for the lot width to be compliant. This application provides 75 feet. That's again a 50% variance. That's 2 more substantial variances that need to be added to this bulk of relief. So in all, we count the 6 significant area variances plus the town law 280A variance, which should all be included as part of the applicant's proposal. You know, we argue that any one of these 7 variances, standing alone, would be a detriment to the community and have an adverse effect not only on the physical condition of the surrounding area, but also the environmental conditions of this eco-sensitive waterfront area. This property that they want to build on backs up to the water, and there's wetlands there. So with an already strained dimensional lot, you want to build against wetlands, it's a cause for concern. Taking collectively, the collective impact of these variances basically amounts to what is illegal spot zoning. You'd essentially be rewriting the entire code to fit this application. It just doesn't work. So what it boils down to is that the application is just so out of character with the zoning plan. It doesn't really make sense for the area, and it should be rejected. I also wanted to note that the subject premises is actually located in a designated FEMA flood zone as well. Another thing that we noticed, I don't think the application referenced that. It's partially located in an elevation 6 and partially in an AE elevation 7 zone. So if you take into consideration the base flood plus 2 that just the first floor level would have to be built at, we're talking about a pretty sizable, substantial structure that doesn't fit already on this size lot. Those are the area variance issues that we have. Another significant issue that we found was, we believe there's a lot merger that occurred here between the 2 parcels that the applicant owns. The applicant, as I understand it, has maintained in his application and in his testimony that he had single and separate ownership for these 2 parcels. The 2 parcels I'm referring to are the subject premises and 242 Overlook, which he owns to the north. From our research, our title research that we did, we found that the applicant took title to the subject premises by deed in 1985 under his name, Edward Hocker. So he purchased this property, the subject premises first. Then, about 8 years later, in 1993, he purchased the property to the north, 242, also in his name. That should have triggered a lot merger. These lots should be treated as one zoning lot and not 2 different developable lots. That's another significant issue, and I just wanted to hand up, to support what I'm saying, I wanted to hand up to the secretary, to the board, the deeds that I referenced. The current deed to 242, the current deed to the subject premises is held by an LLC, but when it was purchased in the individual name. So what I'd like to hand up is the current deed, the source deed from 1985, and the 242 property information showing ownership. We believe this is important. I'd like to hand it up. So again, the multitude of variances, the lot merger issue that we believe occurred in 1993 when the second property was purchased in the same name, believe that, you know, the applicant cannot justify his application by saying that it's a hardship to not being able to build on this lot. He has a home on the adjacent lot. You know, you take zoning as it comes. It's part of your due diligence when you purchase property. It shouldn't be the board's, it's not the board's fault, it's not anyone's fault, it's just, it's part of the due diligence of purchasing property to know what you can build and what you can't. Another thing I wanted to mention regarding neighbor opposition, several of the neighbors are pretty strongly objecting to this, including the Kleins, who
Send us a letter. We have it.
sent you a letter. Okay. They raised some good points. I just wanted to note for them, since they couldn't physically be here for work obligations. Their June 13th letter mentioned believe I already referenced, it mentions, and shows figures about what the lot line, where the setback line should be for a zoning compliant property, and where the wetlands, the New York State Department of Environmental Conservation wetland setback should be. So, I know you have it, I'm just gonna hand off this letter again from the neighbors, the clients.
I'll put it with the package.
So, before I hand it over to my client and to the neighbors, who I believe have other comments they'd like to make on their own, in conclusion, the board has to weigh all the 5 factors in the town law when reaching a decision, and the equities in this case are clearly heavily weighted against the applicant. The detriment to the community far exceeds any benefit to the applicant, who already has a home on the adjacent lot, and should, if these lots were in fact merged and treated as one lot, it would be a zoning compliant lot, and that should be enough. And for the reasons stated previously, you know, we believe that before the board can really make a determination, all of these issues raised tonight and at the May 24th hearing need to be addressed somehow in a final fashion. And we would like to, we would request that we keep the record open while we do so. If there's any other negotiations that need to take place, I'm sure they will between now and the next adjourn date. That concludes my comments. If there's any questions for me, I'd be happy to answer them. Otherwise, I would hand it over to my client.
Counsel, I just have a couple of questions.
Sure.
I'm just looking at these deeds and I'm seeing that, it's pretty straightforward that there's a right-of-way in common with others over a 16-foot right-of-way adjoining said premises on the west to and from Peconic Bay Boulevard. Are you suggesting that that's been revoked or in some other way ineffective?
No.
Then how is it that you're claiming that they don't have access and they need a 280?
280,
Variance.
Town Law 280A states that it has to be a mapped roadway, which this is not. This is an unmapped right-of-way. So,
So you're saying this is an invalid deed? The right-of-way contained in the deed is ineffective and invalid?
the access
Despite the fact
rights,
that they've been using it since apparently 1985?
the access rights stand. They're valid. The easement through the right-of-way is valid. Town Law 288 addresses a different concern, which is that if it's an unmapped roadway, the zoning board or whoever is tasked with hearing 280A variances, they're pretty common. We deal with
I'm
them a
very
lot.
familiar with them. Have you researched the town clerk's records to determine whether or not the town has adopted Overlook Drive as a town right-of-way under town law, section 189?
I have not had a chance between when I started preparing and now to do that research. I would,
If you discovered that that was the case, would that change your opinion?
if it was a mapped roadway, if it was a mapped roadway and the town adopted
Doesn't have to be a
it.
map roadway, it can be a town roadway pursuant to town law 189. So if the town has adopted this as a roadway, by virtue of its maintenance of that roadway over a period of years, and it's adopted in a resolution, then it would be a town roadway. Would your argument change?
It would possibly change my argument, yes.
And so
I don't
just
know the answer to
looking
that
at Lot
question.
2 on the map of COP, I'm just looking at the house on Lot 2, and I'm just looking at the setbacks there from the lot lines, and it looks to me like one of those setbacks is less than what is set forth in the current zoning, excuse me. And not only that, the accessory concrete block garage is also 20.4 feet off that property line, and I'm just wondering, you know, whether there were any variances granted with respect to that structure when it was constructed.
I'm not sure what, I don't know if we're
The
looking at the
house
same
built
thing.
on Lot 2 on the map of COP, the four
On Lot 2,
lot split.
Lot 12.2. I'm not familiar with the history of that parcel, so I don't
And
know.
are you aware of whether the house is located at 257 Overlook Drive obtained any variances prior to its being constructed?
257?
Yeah,
That's my client's property.
Yeah,
and
that's
I
correct.
believe that when, and we didn't represent them when the subdivision occurred or when they purchased it. My research was confined mostly to the subject premises, so I don't
so
believe
if
that.
your client when they constructed their house, obtained any variances relating to those lot lines in the RB 40 zoning.
RB40.
Um, You know, I think the board ought to know about that.
Dawn, may I see that? And the 2 deeds, when you have time.
Because it looks to me, I'm just looking at an aerial, and obviously that's not accurate, but it looks awfully close to that southerly lot line there.
My client-
Way closer than 25 feet.
Whatever was approved was, my client could probably add a little more color to this in detail, but I believe he bought it from the developer from the Kopp estate, and it would have been, no, I'm gonna stop talking because I'm
So before I go
incorrectly
on to the
stating
next
it.
question, and that's just something this board can
Okay.
research on their own, but, with the town records. But the Hocker parcel that is the subject of this application, are you suggesting, let's leave the roadway issue aside for the moment, are you
Sure.
suggesting that based on the current zoning and the merger issue aside, cause that is an interesting issue, that it would be not a buildable parcel, that they would not be able to build on it at all?
We would be curious to see a plan that is zoning compliant, which we haven't seen yet. This requires a lot of substantial variances. If there is a plan to be had that is zoning compliant, or at least substantially conforms with zoning, which this plan doesn't, we'd be, I would think, interested to see that. These are definitely not de minimis variances, they're pretty substantial. I don't know if there is a plan.
Recognizing the fact that the zoning was applied to the parcel, you know, probably after it was created, and restricts the property to probably being non-developable with a house. I mean, if the setbacks, what's the total of the side yard setback? On those, Mike, does it, I don't have the application in front of me.
Here, let me get it for you.
I mean, the lot is 68 foot wide and the combined side yard setback requirement is 55. How do you figure they're gonna put a house on that?
I don't think it would make sense.
Well, but then.
I
if
think
the-
that,
If that zoning was confiscatory, then the town would have to purchase the parcel, right?
well, not if it was in fact, because the other point, the important point is this lot merger, if it was merged, then
I just said aside from that issue.
but it's
I
an
mean, don't
important,
you agree
it's hard to
that
take that out of the
if the
equation.
zoning is applied to a pre-existing lot, if in fact it's a pre-existing lot, which we don't know at this particular juncture, but assuming that it's a pre-existing lot, and the zoning basically precludes any development of it, that's what this board is for.
I think my answer to
Otherwise,
that,
it's confiscatory, it's an inverse condemnation, the town would have to purchase it.
putting it aside the merger issue, which would make all this moot, putting that aside, the zoning board's purpose is to relax, reasonably and responsibly relax the zoning ordinances when it makes sense and when it
But if
doesn't
you can't
have
build
a
a house
detriment.
within the existing setbacks in any way, how can they conform?
I don't, that's their issue.
Well,
An
it looks
owner
to me
would-
like maybe your client might have had to get a variance to relax, because he looks awfully close to the southerly line. I'm just saying that if the zoning precludes any development on the parcel, then it's confiscatory, and the town would have to buy the parcel. That's what this board is for, to allow them to build something reasonable, but it really depends on.
If there is something reasonable that
What's
can be.
reasonable depends on all of those factors, would you agree?
Right. I would agree, reasonableness may be different, reasonable minds can differ on what reasonableness on this lot would be. But right now, what is being proposed is certainly not reasonable, and I don't think the board exists to fit and cut up their current zoning scheme to fit one owner that may have bought something that he knew that he couldn't develop, bought something next to it, was able to develop, and now is trying to come back at a second bite at this smaller parcel that should really be subsumed into the larger parcel that he also owns.
Perhaps that's something to review for this
Right,
board, but
right.
if the lot was created prior to the upzoning, I mean, that's what this board does this all day long, every day. We upzoned the entire town in 2004. Prior to that, there's tiny parcels all over South Jamesport that are, 60 by 50. And those
Right.
parcels are still available to be developed.
I would say that the way this community has been developed around this parcel, it changes the calculus a lot. And it could greatly affect the property values of the people that have spent a lot of time and money and effort to build these magnificent homes, and it wouldn't fit in the character of the area anymore to build a house on that size lot of this size that's being proposed. So you're right, those are the considerations for the board. We're strongly suggesting that it would be a greater detriment to the community than a benefit to the applicant, and that there may be
How would
other.
it change the essential character of the community, being that those houses are quite a bit larger than what's being proposed?
It's all relative to the size of the lot, and the size of the lots in the community are substantially bigger. There are some lots that are less than 40,000, but they're few between, and this one is much, much, much smaller than even the second largest lot. So those are the concerns that we have.
Okay.
And some of the other neighbors have concerns too. Thank
Okay.
you.
I just wanted to note that on this survey that they applied for, Mr. Hocker, there is an indication and a delineation of the elevation zone.
Okay.
So you said that was deficient on the application?
The application had not mentioned the flood zone requirements. It
It's on
didn't
the
mention.
survey, if you'd like to see it.
The survey, well, I saw it on the survey, but I did not see it on the application or the environmental
okay.
assessment form. It wasn't accurately represented. That's what I meant
Well,
to say.
when they submit a building permit application as such as this, the plans would dictate that. The building inspector would then determine how the structure should be designed to conform to elevation, zone X and elevation
Right.
6. And obviously, the house is pretty much split in half. But I would think you'd have to do the more restrictive. So
Right.
I've never seen what Mr. Hocker is proposing as far as height or in design.
I don't think we've seen it either. Maybe those
But,
plans haven't been
You know,
prepared yet.
he's probably taking a step at a time to see where he can go and what he has to do, so.
Sure.
Okay, thank you.
Thank you.
Step up to the microphone, please. And you kindly raise your right hand. Do you swear to tell the truth, nothing but the truth, so help you God?
I do, but I'm an attorney as well.
Well, then you have the floor. Just state your name and your address.
Anthony Capitola. We have the house at 257 Overlook, one that's almost directly across. And our property actually fronts and is part of the roadway that the Hocker property, the subject property.
We've been there.
I take it you were. So let me start by saying that this is our home that we're gonna be moving to very shortly. We've been there for over a year, I guess we've owned it a couple of years now, and we're in the process of formally moving out here on a full-time basis. Prior to buying the home, looking around, I did some research on it, and I knew that the Hocker property that was across the street had previously been purchased, and as my lawyer said, in 1985. At that time, he did not own the house or the property immediately to the north, which is substantially larger than this property. And as a matter of fact, if you look at the frontal portion of his property and look north, there's substantially more property on the north end of his lots than where this lot is. Easily, much more availability if you consider that this is really a merged lot, and that both properties should be considered as one because of what my attorney has said. We've had a title search done on this, and I did my own research prior to buying the property. The house that we bought from the developer Kopp. When we bought it, and we wanted to make some renovations without variances by adding a porch, we stood well within the setback rules, and we squared off the house in the back. And again, we stood way within the setback rules, and the DEC rules are 75 feet from the tidal waterlands. In doing so, when we made the application and our expediters came to the town, we were told, well, there's only narrow 10-foot side yards between myself and the house immediate to myself, Dr. Lepard and his wife. Well, that's true. That was part of a zoning plan that was approved as a packet, that those 4 houses were set up that way, and it did not apply to the others. If you consider the length of property that goes on our property east and west, there's tremendous amount of additional property. Our property in the front includes the roadway and undevelopable property across the street along the canal there, and prevents us from doing any further construction. We enjoy a wonderful view of the property, and we absolutely enjoy being there. I unequivocally authorized my attorney to offer Mr. Hocker $200,000 for the plot to obviate any hardship that he may sustain, because I believe if you built the house, if you had to construct the house on the lot and build it, that in the end result, that would be a very fair amount of money for this lot in order to take this out of contention here. And since the time I've been there, I've dutifully tried to be friends with the Hockers. I brought them cake every Friday from a bakery I'm involved in. Matter of fact, everybody in the block gets cake.
What bakery?
That's the Mill Ridge Bakery and the Mill Ridge Inn in Nassau County. I love being kind to my neighbors, and that's what I did. And I actually tried to go there this weekend to see Ed and his wife, but when I went, there was no one there. I usually leave the cake at their front inside door, but on this particular occasion, I didn't think it was appropriate for me to go in, because I didn't think maybe they thought it was gonna bomb the house or something. But the truth of the matter is, say what?
You could have brought it here.
Next time I will.
All right.
I got a feeling we're coming back here. But my point being is that I don't want to hurt anybody, nor do I want to be a wise guy. I was on a zoning board of appeals in the town of Worcester Bay. I have been counsel to various other zoning boards. I've appeared before zoning board after zoning board in my own practice in Nassau County. My wife's a judge. We abide by the rules and we abide by the law. I didn't do one thing to my house to go past what was required by the town, even seek a variance to go forward. I said to Ed, when you're building this lot, where the heck are you gonna put the drainage? You know, I didn't realize the magnitude of what he wanted to put here. From what I understand from my lawyer, Chris Coscignano, who's taking his son to play ice hockey in Canada, and that's why he's not here personally today, he told me that the Hockers informed you that there's about 1,000 or 1,100 square feet of construction going on here. That's not accurate. It's 2 stories, and I think it's about 900 feet on the first floor, and the second floor is about 1,100. How did they accomplish that? They have an overhang. Okay, I don't know. Listen, this is what I was told. I'm not gonna address Mr. Hocker now. This is what I was told. So that even though the side yards are as proposed in the application, somewhere in the range of 50% of what the requirement is or thereabouts, with the overhangs that he's proposed, front and back, sides, it's even more of an expansion of the house on this postage lot. Now, I understand the confiscatory argument that council was making there in response to Mr. Capodora's comments, but no one's looking to have that happen. I'm willing to relieve the town of that responsibility by writing out a check. I've arranged financing to do it. We can close in a week, if that's what he wants to do. But when I approached him about it without mentioning a number, he said, I don't want to talk about it now. I don't want to talk about it now. I wasn't trying to be pushy or disrespectful. We've enjoyed a good relationship. I put a cobblestone curb along the entire frontage of his property and dipped it so he could get vehicles on the property. Everything we've done there has been respectful of everyone else's rights. However, under the circumstances, this is a heck of an imposition and is violative of what the spirit of the law is. You can't necessarily buy a lot that's substandard and then say, oh my gosh, I have a lot that's substandard, here's what I'm gonna do. I'm gonna buy the lot north of me, which is standard, has a house on it, and has greater property north of where the structure is. And then what I'm gonna do is, nobody will know, I'll transfer the lot that's in my individual name to an LLC. That way, everybody will think it's in single and separate ownership. Well, no, that's not what the county clerk records say. And if that's the case, he merged the property and he's not entitled to a variance at this point in time. And I'm absolutely confident in the information that we've provided, and I welcome your inquiry, bless you, to the county clerk's office in Riverhead, and you'll see that this is what the deeds show. So now, having merged these properties, he's not eligible for a variance unless you want to say, blink, blink, I'll close my eyes, we're all going to be good neighbors. He put it in an LLC's name. So I don't want to be a wise guy. I want to be a good neighbor. I'm willing to relieve him of his responsibility. I would never build on this lot at this point in time. The most it would be a garden, and would preserve the nature of this property. I don't know that the maps are right that he's relying on, but all I know is that if you go to the water's edge of Terry's Creek there, there's just reeds and everything else. Where is this drainage for his cesspool system gonna be when we're worrying about nitrogen in the systems and everywhere else? On the street, because that's where it would have to be, under his driveway. I don't understand how that could possibly be. Your council's comment about maybe this road has been dedicated, or I forgot the phraseology used, and forgive me, I don't mean to be.
No, it's a highway by use, it's a
Okay.
provision in the highway law.
So the town does nothing with respect to this road. The last 4 people, meaning myself, Dr. Lepard, the Kleins, and Eric Goldberg, excuse me, we paved that whole area and made it very habitable. But if you go down there, and you said you were there, to the property, you need a Humvee half the time to get down to where our properties are. Nobody's maintains that from the town. Dr. Lepard can't get out to treat his patients. My wife can't get to court to treat the people of the state of New York, because on a winter's day, it's filled with craters. The town has taken no responsibility for this property, meaning the road, and the rights of way whatsoever. Once in a while, somebody will take pity on us, and they'll say, well, we have some extra asphalt at the end, we have to throw it away anyhow, we'll give it to you and put it in a hole. But the people that are developing along this roadway and asking for variances and rehabilitating old properties, you gotta make them comply to fix this road, because we can't do it all ourselves. We invited the Hockers and the people, the Kane Cantalanos, who live just north of us, to participate in renovating and asphalting the road as we did, and continuing out a little further. No, nobody wants to do it. So we did. So all I'm gonna say to you is, A, this is a single merged lot, and it's not subject to the relief that this board is entitled to give, and I think it would be illegal for the court, for this board to give it. Number one. Number two, take away any hardship. We'll pay him the money that he could possibly net as a result of the sale of this, and I think that's a fair number. Number three, all 4 houses in the back were totally compliant with the zoning. There were no variances granted at all. They were all part of a 4-packet with special zoning for the side yards because of the elongated nature of each of the lots. For example, myself, Dr. Lepard, and the Kleins in the back, and Eric at the end, all have a tremendous amount of open space that was not available for development in exchange for what the COP developed. When Mr. COP developed it, he got these smaller side yards. So I researched this before we came here. I researched it very thoroughly, and I knew that that was a single lot now that had merged, and I knew that all of our properties and our property and the property of our neighbors to the south all were compliant. So I'd ask you not to grant this, or if you want, grant them an extension of time to consult with me, because I'm making that offer right now. The check could be written out in a couple of days, as soon as we get a title report, and it absolves the town from having to confiscate anyone's property. No one wants to do that. And I'll still bring them cake.
Speaking of the title report,
Yes.
how did you determine that they were merged?
by the argument that Mr. Capadora just gave to you, but I'll outline it to you again.
Well, no,
Do
did
you
you,
have a
did you hire a
report?
title company to?
I didn't hear you, say it again, sir, I have hearing aids. Yes,
And do you have a certified copy of the?
I don't have a certified copy, but what I
They
did is
it
once
in,
the,
informally for you?
excuse me?
They did it informally?
No, I use title insurance companies every day. I've been using the same company for about 48 years now, so.
No,
it's-
I'm not trying to be.
Oh, no, I paid for it, and once they told me what they found, then we went and checked the deeds ourselves, but I had checked this
Well-
informally before we bought it. That's 2 years ago.
Do you have a copy of that report that we could?
I don't have it with me, you'll have it in a matter of a day or two. I've been on trial all day in Nassau County, I barely could make it out with the accidents on the expressway tonight, so I'm here under a little bit of duress. Yeah, why don't you tell him, may he come
Yeah,
up and
please.
explain to you
Please.
again?
Thank you.
I gave it to my attorney to handle, of course, he had to take his son to Canada, and he's this fine young man substituting, but if you wanna ask me any more questions before I sit down, I'm happy to answer them.
Okay.
You've done well,
Just
Counselor.
one more
Thank you.
question.
Do
Are
the
you-
best I can for Simple
do
Country
you-
Board.
the-
Oh, sure.
On the lot two, I don't know which house this is, in the, on the map of COP, the middle, the long one that cuts through the middle. That, it says on this map, existing stucco house, so there was a house there when the subdivision was done, are you aware?
What happened was, and I, Dr. Lepore could actually speak more clearly.
Counsel, if you just go to the microphone,
Oh,
please.
I'm sorry.
That's okay.
I couldn't hear it, so that's why I stepped up.
I hear you.
I apologize to
I'm
you
sorry if I wasn't
folks.
speaking loud.
Yeah, no. Let me try to explain what happened. Years ago, I met Dr. Lepard totally by chance at a mutual friend's house, and he told me he was interested in buying this wonderful piece of property, and that there was a garage on it and a house that was falling down. They could give you the history on that. That ultimately was taken down as well as the
Okay.
house that was falling
So
down.
there was a house there when the plot was subdivided,
Then when it was subdivided, that was all eliminated.
got it.
Now, when you said stucco, my wife was, we have our house stucco.
It's just on this map, which isn't a certified copy that I'm looking at or anything.
Is that yours or ours?
I believe it's ours.
Okay.
It says existing one-story stucco house, existing concrete block garage. So that makes a little bit more sense.
That's all gone.
And I just, can we ask Mr. Hocker to come back up?
Yeah.
Hey, Fred.
When
Fred.
they're done, we'll ask them to come up.
That was gone before I even went into contract. Again, I must have met the Lepards about 5 years ago, and he told me about this.
Okay, thanks.
You're welcome. I'll bring the cake the next time.
Mr. Hocker, would you please step to the mic?
I don't know how it could be a merged lot. It's in two separate names, Edward and Patricia on one deed and Edward on the other. That's not the same ownership. It's two separate ownerships, the way I understand it.
Do you have a title report?
I turned it in.
You do, okay.
Yeah, I turned it in with the application.
To the building inspector? You turned it into the building inspector?
Well, yeah, I had to, not, when I made the application, that's one of the requirements, the title report.
So you gave a certified title report
Yes, from
showing,
Fidelity Title, yes.
showing.
It should be in your papers, or,
Do you have the?
Sir,
I don't have it.
you're before us tonight and you're asking for a lot of relief.
right.
And you have this gentleman here offering you $200,000 for your property. What do you have to say to that?
I say I'd like to build a house.
Okay.
It's a small house. I mean, they make it sound like, it's small. You people know, well, you weren't here last time,
No.
the problems I had. I shrunk it, the first time I was turned down, I shrunk it from that. I can't do anything else with it because of the setbacks that the DEC wants. I had to reconfigure the drainage. I had to move the driveway to the south, so I've done everything that's been asked of me.
But it's a lot of relief.
I know. But it's pre-existing non-conforming, from what I understand. And I mean, if you want history, I got pictures of what, they're talking about a little green space that I got there. You wanna see pictures of what it was before they put that subdivision in? I got pictures.
That's what I see. Anyone else to be heard on this matter? You wanna,
Where is it?
if you have anything more to add than we already gotten, just step up.
Mister, we're worried about this little green space, that's my property. We want to save the green space. This is a picture, I took of a picture. This is a little blurry, but this is what it looked like. There's my house. This is the
That's all,
peninsula,
that's the
where
rest
all
of,
those
all I
houses.
have.
I'm aware of it.
Yeah, I know.
I've been there.
I know. I just want,
I mean, that's, to us, it's irrelevant at the moment.
Right.
I know you're trying to make a point. But, so you have information from a title company that shows chain of title.
it shows this, the lot, not my existing house.
Maybe go back to the mic, please.
Sorry, we couldn't hear what was being said.
He's coming
That's why I
back to the
told him
mic.
to go back to the mic.
Yeah.
I turned in a title
We're
report.
talking about the title report, just so you know. And I said, okay, so you turned the title report in, but is there a chain of title in your title report that disputes or verifies that it's either in single and separate ownership or it's merged?
It's in single and separate ownership.
Since when?
Did you do a single and separate search on it? Have you done, was there a single and separate search done? Because I don't
All
see
I
the
did is
title
what-
report in the application papers for
You
some
don't
reason.
see the title report?
No, we
No.
don't.
I wonder if I have it with me, I doubt it.
The board will definitely need to have that.
So what was the purpose of you creating the LLC?
My nephew's an attorney, and he suggested, I can't even remember what the purpose was.
Okay,
I guess it's a limited liability. I mean, if somebody hurts themselves, you don't, you know,
Is
they
that
sue
on-
the LLC, they don't sue me.
without me looking at the deeds and searching it out, is it on the right of way or is it on a particular lot?
Say that again, sir?
Is it the right of way that's, we're talking about, or is it the lot itself?
The lot. I don't follow you.
Was the lot, is it in your name or was it in the prior name under your LLC?
It was in my name, and now it's an LLC.
So the lot you have now that you want to build on is in an LLC?
Right.
So it's not Ed Hocker, it's some other name?
It's, yeah, right.
Overlook
It's a
Drive
single-member LLC,
Okay.
okay? My wife's not in it, it's still me. I'm the only one,
Prior to that, on the conveyance,
right?
what was in the name of?
Edward Hocker.
And the parcel to the north, which you are, is your residence.
Edward and Patricia,
Has it always been Edward and Patricia?
Yes.
Always?
yes,
From the first day you bought that lot?
yes,
Always?
yes.
Okay, just asking.
It's not merged.
So, you have a title report that indicates that?
I didn't get a title report on my house because it wasn't, you know.
Well, we have to determine, the town has to determine whether or not there was a merger.
What about, the deed says Edward and Patricia. The other deed says Edward.
Well, the
Then
title
LLC.
report would verify whether or not that was merged by operation of law through a deed.
So what,
So.
we have
would
one
need
title
that.
we have one title report.
on the current parcel.
Right, but I'm trying to get it squared away so he knows what we're talking about for his sake.
We have one
So-
title report for the lot. Now, you want me to bring a title report for my home?
No, I wanna see a title report on the lot that shows how the lot to the north that you live in and to the southern part, which the lot at subject here, what we're speaking about, has it ever been merged?
No,
by ownership. Okay, that's your
No.
testimony, that's fine. But we're gonna want one,
Well, I think.
whether from
I
you or
already
from
turned it
them,
in.
and maybe
I think
both
we
parties.
need a single and separate search on the subject parcel.
I turned it into the, I
We
turned
don't
it
have
in.
it,
I
Can
turned
you
it
make,
in.
look, you're here at a hearing for us.
Right.
We
Carissa
don't have
probably
it.
has
It's
it.
not in any of this.
Not in the
stuff
package.
or something.
We'd like a copy if you can provide it again, maybe it got lost.
Okay.
I don't know.
Dawn went through it, I don't have it.
It's not in that,
Okay,
yeah.
you know what you need.
Unless I miss it, but I don't see it.
How long
copy
ago
of-
was the title report, Mr. Hocker?
Excuse me?
How long ago?
6 months.
Okay. So
I
you're
mean,
making,
again, this is what it required when I filed the application.
I don't dispute that. What I wanna see is the report ourselves. We don't have a
Okay.
copy of it, I apologize. And,
Good.
and the people that are opposed to it will also provide a copy to us for the
Okay.
record, so that they are both consistent, so we know what we're looking at.
Okay.
Fair enough?
Fair enough, yeah.
Okay.
Anything else?
Doctor, you want to come up and say something? Please, step up.
Hey, John, wait a second now.
Take your time.
Oh, anyway, I know Tony brings me cake and stuff like that. Very nice man, I like it. He put the Belgian block in. He didn't mention that for 6 months when he was building his house, I said, yeah, go ahead, park on that lot.
All right.
No problem, I'll be a good neighbor. After it was all done, he planted grass and everything else. But it's not just a one-way street,
All right. Thanks, Ed.
okay?
Doctor, please step up. And doctor, if you kindly, since you're not an attorney,
No, I'm not an
raise your right hand. Do you swear to tell the truth?
I'm just a
Nothing but
doctor.
the truth, so help you God.
Yes, I do. My name is Dr. John Lepard. I'm a little out of my element. Thank you for taking all the time, and I hate being in this position. We moved here full-time, my wife and I, with intent to expand my practice here. I love the community, absolutely love it. Crappy road and all.
There are a few potholes.
There's more than a few.
I lost half
And
my
I
teeth going
love
down
my new
there.
neighbors. Ed and Pat, nicest people in the world. My wife came down with cancer, it couldn't have been nicer. There are a few of us, total of 4, who took this beautiful piece, realized the goal, how beautiful it was. I couldn't even get down that road when I first saw it. They said it's not controlled by the town, but I like that. Found the little piece, there was a stucco house, I ruined my car getting down there. Eventually bought the property, couldn't be happier. Myself, we kept everything understated, we lived within every guideline, every law, every requirement, within a foot. There's no, get closer to the water, let me do this, and there was no variance, we lived within those laws. So, you gentlemen have a lot more knowledge about this, and certainly my colleague, my friends do, so I'll trust this to your hands. So I'm gonna just say this as a neighbor. I basically represent the other neighbors, all of whom are out of town. One has a job.
Klein sent us a letter.
Kleins are out of town. They bought, and he was transferred to Melbourne, Florida. Goldbergs have lived there first, have been very kind. Jim, all the neighbors, we didn't know this was happening. We saw a sign, Ed had told me years ago, he said, you know, I'm gonna build something there, and we certainly had no problems with him building anything. He's a gentleman, I assumed this is all kosher, that he could do it, but we assumed that it was going to be something in compliance. So, I guess the thing that affects us is basically that laws are made to be followed. We didn't ask for anything special, and I assumed that there would be a small guest house there, a small house of some sort that would be in confinements, and nobody knew the extent of this, and I wouldn't have had basically Tony not said, he said, did you hear there was going to be a hearing? And I saw the sign went up, and I said, what's the hearing about? I said, he's certainly able to build a house. I had no issues with it. He said, but you don't understand the variances. The other neighbors found out, and frankly, they were quite in a brouhaha. To a certain degree, we basically disagreed. We thought there was rules were made to be followed, and everybody has to follow them, and that if a structure was gonna be there, it should be a fair structure that was in keeping with proportion of the property. You know, I'm not a builder, I don't wanna stuff something. I don't know if we need more McMansions or how you're gonna fit this, but And again, it's his property, but I know that the property that he has is large, and discussions were that Tony was gonna buy the property, which seemed like fair relief. And then there was discussion that on the other side of his house, he has more room if he wanted to build a house over there. So there seemed to be plenty of other options that were fair and would keep everybody friends. And I hope at the end of this, we're still gonna be friends, whatever you all decide. Says, I don't wanna lose friendship of anybody over this, but I will say that I'm speaking for the other neighbors, that we do take exception to this, because it does adversely affect the area that we're trying to lovingly develop as it should be. We've asked the town to help the road. They said we have no say in this, but now here we're asking for some common sense. We're concerned about the green space. We're concerned about, first, the law, second, the precedent that we're setting. We're afraid that, I guess, anybody can put any size house anywhere they want along this road. I don't think that would be wise. We're concerned about the safety. As you gentlemen and ladies probably know, it's barely passable as it is. I really can't get up and down that road. We have paid personally our own monies, the few of us who agreed to fix those potholes. Very few people, in fact, nobody would do that. I talked to the road gentleman here in Riverhead. What's his name?
Gio.
He's great. And he came out, he said, I'd love to help you, Doc, but he says, I can't. He said, it's a private road. And it's our responsibility, but the safety does concern me. There are times if a fuel truck comes down there, you can't get by. When I bought that property, to be a good neighbor, expanded the turnaround so that trucks could come down because it was a dead end. Initially, when the cops had it, there was a electric gate, and the idea was that this was gonna be a private community, so that you'd come down there and you couldn't get to the end of the road. They had an electric gate there, which was supposed to be put back.
No, they wanted to put it back.
Right, I
It's
thought it was
illegal.
ridiculous. I said, how could you do
It's
that?
not wide
People-
enough.
Right, well, that was what was told me. I said, that's absurd. I said, how are trucks gonna get around? So instead, out of my own expenses, I expanded, and the neighbors, as you said, improved the road to allow for. So basically, we've been good neighbors at that end. I wish some of the other neighbors would do more to help, but they don't. So I know I speak for the others that, with due respect, they hope that there's a compromise, either a small structure that fits appropriate. We assumed it would be a guest house, little guest house, fitting on a little plot, a little cute cottage. The plot I bought, that's what it was. It was a stucco home and a little garage. They weren't livable, they were condemned, but they were there, and I thought that's what's gonna be. And we would not have found this, the neighbors had Mr. Capitola not brought it to our attention and asked, we didn't really wanna weigh into this, because it certainly adversely affects Mr. Capitola the worst. We could easily all sit on our fingers and say, oh, it doesn't matter. But if you're asking their opinions, yeah, about everybody's unanimous that there has to be some more fair way of resolving this, either financially by him buying it, him putting a house on the other side where he's got the room, or building a structure that's appropriate that will maintain the value and the character of the area. I don't see a McMansion, I don't know how you can do it, I'm not a builder, but I'm hearing, flood levels, second floor, high, when, we wouldn't go within 75 feet of the water because we were told we couldn't, we didn't. So the question is, everybody else applied these laws, and now we're looking for a gross change in the law.
Well, I think people have to keep in mind that that was a subdivision done by Mr. Cobb. I don't know when he did it, but it was probably about 20 years ago, maybe even less.
Probably right.
And when they do a subdivision like that, they'll give the variances typically to those lots at the time the subdivision's approved, and they create the building envelopes. And that's why you have those houses inside the envelopes. And additionally, they deal with the setbacks and the wetland issues at the same time. The 75-foot setback is a jurisdictional issue for setbacks, but they conform to all that. But I don't think anybody's really pulled out the subdivision and looked and see what were the covenants, what variances were given, if any, which I don't know. I'm making an assumption here. But when they do those subdivisions like that, they typically do the granting of the variances as long as they stay within the building envelope. That's really pretty basic stuff. So
Well, you're,
and the law also requires that you have a minimum size home in the So
Yeah, I
you can't have a summer cottage either, or a
Yeah.
guest house,
I heard that.
because
Yeah.
he would need relief to have a smaller home as opposed to a larger one. So,
I heard
I
that.
think
They-
it's 1,500 square feet is the minimum, which I'm not sure.
Well, there's houses that are falling down and shacks all up and down there. I'm not
I'm
exactly
talking
sure
about
how.
what the code says about
But I
sizes.
understand, but it just seems impractical that you say it's gotta be this, and even though the lot is too small, we're gonna stuff it on there anyway. I mean, that's the definition of the mansion. I mean, we're talking all over Long Island about maintaining green space.
Well,
I mean,
You know,
I think
zoning
this is,
can't be written specifically for each lot.
no, I understand.
So they write it generally, and then that's why there's a zoning
I-
board as a relief valve.
I understand.
That's what it's all about.
I understand.
That's all we're talking about.
But, I mean, as gentlemen and ladies that are responsible for this beautiful area and preserving what it is, I cringe frankly to think that, well, let's make all these compliances, cause he can, and let's stuff everything in we can, cause it's a nice area. And I'm just saying, what a beautiful spot you have, it's so preserved, and we're trying to preserve it to do what's right. I mean, as a zoning board, that's your job. You're supposed to take all
Absolutely,
the.
that's why we're here to hear the testimony and
You know what I
find
mean?
out
I-
what the facts are.
We
I
wanna
mean,
do what's
may be
best for
wasting
everybody.
everybody's time and find out it was merged.
Right.
That's
We're-
it.
You guys can find the law, I'm just trying to bring the practical
Right.
sense. There's 5 people who love the area, who wanna preserve it, who are relying on you to do the right thing to preserve it, and not to start some sort of precedent that, well, you can put anything you want because it has to be 1,200 square feet. Because I think there's gonna be a lot of development, I suspect, up and down that road. Hopefully, somebody will fix that road. But I'm getting this vision now that anybody can put up anything where they want. And I said, in such a sensitive, preserved area, I think you have an obligation. I mean, you spoke about Jamesport and a spot here and a spot here. I mean, this is a special place that, I know the other neighbors are very concerned about not only its value, but the wetlands, the green system, the space that the houses have. I mean, we've done a lot, I guess you gentlemen have been out there, we've done a lot to
Absolutely.
nurture it and
Yeah.
and
It's a beautiful
plant it,
spot.
and care for it lovingly, and with all codes being preserved. And then we turn around, it's like whiplash, and you said, oh, by the way, they're gonna put a McMansion over this house with no septic system, and we're saying, how can that happen?
Okay.
It doesn't sound, so,
I think we're,
I humbly
we get where
hope
you're
that
coming
you
from.
can find resolution.
Yeah.
Small house.
we have plenty to go over, we have to do a little more research, but let's leave this open till the next meeting,
That's fine.
and we'll see you
So,
then.
Mr. Chairman,
Yes.
can I at least state that both parties need to provide a certified title search when indicating whether or not it is in single and separate ownership? And I think that would solve a couple issues.
Okay.
I'll leave that to you,
So,
but that's,
I hope it's agreed that, both sides will do that.
Thank you. Yes?
Sir, that was a great presentation, thank you.
If I had built the house there 5 years ago before they moved in, I don't think that would have affected anybody moving in. Would have been a nice little house, they still would have came and built their house, everything would have been fine. I mean, Tony's lawyer even said, I understand it can't, I listened to the video, it can and should be developed, he said. And here's what Mr. Klein says. The owner knowingly purchased the property and its limitations and therefore cannot use grounds of reasonable return. There is no hardship. That's totally false. That the lot was bought, as you people know, when the zoning was different. I didn't create the hardship.
I'm not saying anything about that.
Thank you.
Okay.
Thank you.
Let's move this on to the next meeting. Do we hear a motion?
Mr. Chairman, I move that appeal number 18-022, Overlook Drive LLC, be adjourned till, June 28th.
Second.
Mr. Barnes?
Aye.
Mrs. Worthington?
Aye.
Mr. Seabrook?
Aye.
And I vote aye, so see you folks. Thank you for your representation, and any information you get back to us, please get.
I'll ask if we adjourn one more meeting only because I may be out of town that day, and there's just limited time I have to order the title search and so forth. They may ask, but I want to be here that day. They asked if we.
I think that's fair enough.
Yes.
First meeting in July. July 12th.
Mr. Chairman, I move that the appeal, correction, at
fair enough.
18-022 be, adjourned till July 12th.
Thank you, ladies and gentlemen.
Second.
Thank you.
Mr. Barnes?
Aye.
Ms. Worthington?
Aye.
Mr. Seabrook?
Aye.
And I vote aye. July 12th it is.
I'm seeing the
So I'm interested in making it to the past.
Dawn, do you have the paperwork on that?
I do.
Okay.
There's some, this is,
All right, kiddo, off we go. Is that it too?
Next is appeal number 2018-025, Thomas Marceau, 17 Plainview Drive, Wading River. Tax map number 649-3-3, RB80 zoning for variances and or relief from chapter 301, section 34, where the proposed side yard setback is 11.2 feet and the minimum required is 20 feet. The affidavits. Do you have the affidavits?
Yes, I do.
And you are?
I am Todd O'Connell, the architect.
You are the, if you kindly raise your right hand, swear to tell the truth, nothing but the truth, so help you God.
Yes, I do.
Kindly state your name and your address.
Todd O'Connell, doing business at 1200 Veterans Highway, Hauppauge, New York, architect for the Marceaus. Thank you, Chairman, members of the board. Representing the Marceaus in their request for relief of side yard setback. What they are trying to accomplish is to gain a family room space on their home, on the main level of the house, as well as maintain a garage on their property attached to the home as well. Some of the other requirements that they're looking for are a nice mudroom space and a full bathroom on the main floor and an enlarged kitchen. A little bit about this particular property. There is the front of the house, which is a two-story home, and it's as you go to the back of the house, the grade dramatically drops off at the back of the home. The back of the home is developed with a fairly large wood deck, which was new railings and some nice new decking on it. They posed me with preparing a plan to basically accomplish their goals. And looking at it, we first thought about trying to keep the garage and to build to the rear of the house. Telling me a little bit about how much they spent on restoring the deck that's already there. Looking at the topography of the property, the way it drops off in the back. It's actually a walkout basement in the back. Therefore, the economics of trying to build anything on that back part of the house would be substantial. You know, they were looking to, you know, keep everything kind of on one level, not to have to build a big foundation, and you know, so I was dealt with the coming up with the plan that would work for them. So I proposed to convert the existing garage that they currently have into their family room space, and to maintain an additional two-car garage on the side of the residence. This particular two-car garage unfortunately would encroach into the required side yard setback, leaving a side yard setback of only 11.2 feet. This particular zone, as many of the zones are, we have 80,000 square foot requirement. It is in an A80 zone, and the property itself is only 22,000 square feet. So obviously with the greater setbacks that would be posed on that size property, it doesn't give us much space to work with on the side of the home. So we felt that this was the best option, you know, to put before the town and the board. We didn't feel it was going to have a negative environmental impact. We didn't feel it was going to have a negative to the character of the neighborhood, because this is actually another house which is actually on Southview, which is right around the corner, which had a similar variance, but that particular variance was for a two-story residence. I know of this because I was actually the architect on that particular project. That particular home yielded a 14-foot side yard, yet it was actually in a B80 zone. And it was also a larger lot on that particular property as well. So this is only a 1.5-story structure. We felt that the proportions of it, would be in keeping with the neighborhood. I explained, this is really, we felt was the best option. I explained why we felt this was the only alternative put before the board, and it is a proposed construction, which is why we're here to request the relief today. And with that said, I would love to answer any questions the board may have.
Sir, you're asking for a relief with a side yard setback of 11.2 feet.
That's correct.
On the survey that I'm looking at, it says you're looking at for 11.6, which is 11 feet 7¼ inches. There's just a little bit of a discrepancy there. Well, what's important is what was it posted for? Sorry?
It was posted for,
11.2.
yeah, because it says on the back here, 11.7¼
Yeah,
Yes, on the survey, correct.
yeah.
So actually, it should be 11.7¼ right?
If the survey is correct, that would accomplish our goal of having a 20-foot interior garage, which is what the main goal is, to have 20-foot clear on the inside of the garage, which is what I feel the minimum is to have a 2-car garage, which is what their goal is. So the survey was a newer survey that was done after the plan, so assuming that the survey is correct, it was done by a professional, I could say that 11'7" would be fine.
Counselor, do we need to repost? The statement says, well,
like
11.2 is
5
what it
inches.
says.
No, it's just more. 5 inches.
That's fine with me.
Yeah, okay. Anybody else have any other questions? Anybody have any problems with this? Nothing? No dissension?
No tension?
Yeah.
No dissension?
11.7 and 1/4. Go for it.
I move that the appeal of Thomas Marceau at 17 Plainview Drive, Wading River, tax map number 649-33, RB 80 zoning for variances to and relief from chapter 301, section 34, where proposed side yard setback is 11 feet 7 inches and 1/4, and the minimum required is 20 feet. Be granted in accordance with the application, the sketches with the amendments thereto, if any, as filed with the building inspector.
Second.
Mr. Barnes?
Aye.
Mrs. Worthington?
Aye.
Mr. Seabrook?
Aye.
And I vote aye. So best of luck with the project, and have a good summer.
Thank you very much. You too. Have a great night.
Okay, Old Steeple Church.
Appeal number 2018-026, Old Steeple Church, 656 Main Road, Aquabog, tax map number 600-67-125.1, BC zoning for variances and a relief from chapter 301, section 254 F1, where the proposed replacement freestanding sign is internally illuminated, which is not permitted.
Anyone here for Old Steeple Church? Okay, let's go to the next one.
I mean, nobody appeared? Wow.
Is it the first time it's on?
Yeah, first time. Let's see if somebody shows us. Let's go to the next one.
Appeal number 2018-028, Ann and Carl Verdi, 135 South Road, Wading River, tax map number 600-3312, RB 80 zoning, for variances and or relief from chapter 301, section 29, where proposed accessory garage is partially located in the front yard and is not permitted, and section 34, where proposed garage is 8.6 feet, from the principal dwelling, and minimum required is 10 feet, and proposed garage in the side yard is 10 feet from the property line, and minimum required is 20 feet.
Leroy, you're gonna have to take this. I have to recuse myself because I'm right next door.
What the heck?
You heard me. I recuse myself on this one.
Okay, no problem. Have you been sworn in?
No.
I always get mixed up on this one.
Okay. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, self again?
Well, you can watch that on TV
State your
since
name
the
and address.
1950s.
My name is Ann Birdie, 135 South Road, William River.
Because of the God thing. Sorry. Okay,
I'm sorry, go
so,
ahead.
Okay,
why don't you tell us about your,
We'd like to build, 2-car detached garage, 22 by 24, to the left of our property. And, it requires a variance on the side because it's too close,
okay,
and from the house. And it's slightly to the front of the house, kinda lines up with the front porch.
we see that. And, you just need a garage, you're gonna put space above it, you're gonna have
No,
living
just a-
space?
Just a 2-car garage.
Okay. And so you'll have nobody living above the garage?
No.
Okay. So, I don't really have any other questions. The building inspector tell you that, you know, those fire codes require 10-foot separation. So when you build the garage, you're gonna have to provide some kind of like a hardy planking on the siding. I don't know if you're aware of that or
No,
not.
I wasn't aware of that.
Well, you need to be aware of that, cause it may change design and what you have to do, or they can develop some other kind of, construction methodology to deal with the separation of the two structures.
I'm not sure I understand that.
Well, you need 10 feet, because,
Between the house and the garage?
correct,
Okay.
they did that because of spread of fire. So
Okay.
typically, I mean, we're gonna give you relief, but the building inspector is gonna ask you to have some kind of a fire protection barrier on that wall.
And what would that be?
For fire, it might be, a certain material
Oh, I see.
that you'd have to use, but I don't think you'll even see it, because they could do double sheetrock, there's many ways
Okay,
to do a firewall.
alright,
There's not just one option.
alright,
Just keep that in mind.
alright, thank you.
Okay, I have no other questions.
I don't have any questions.
Does anybody have the reading, or do I? I did, I lost it.
No, I have you on.
Oh, wait a minute. I found it. Okay, I move that the appeal of Van and Carl Verdi of 135 South Road, Wading River, in the RB 80 zoning district, for variances and relief from chapter 301-29, where the proposed accessory garage is partially located in the front yard is not permitted, and section 34, where the proposed garage is 8.6 feet from the principal dwelling and minimum required is 10 feet. The proposed garage in a side yard is 10 feet from the property line, and a minimum required is 20 feet. Be approved in accordance with the applications and sketches with amendments thereto, if any, as filed with the building inspector.
Second.
Roll call,
So,
Mr. Seabrook, oh, okay, sorry.
Seabrook votes yes.
Worthington votes yes.
Mr. Barnes votes yes. So your appeal has been approved, and you'll proceed on to the building department for further approvals. Thank you. Okay, Fred, we took care of that one. They're gonna build you an apartment above. Cause you're getting tossed out of the other house.
Just almost the price of that.
Well.
Okay. Next up.
Appeal number 2018-029, Charity Asuna, 81 Beach Road, Wading River, tax map number 626-3, 28.1, RB 80 zoning. For variances and/or relief from chapter 301, section 31, where the proposed property line will create a rear setback of 2.6 feet to the detached garage on lot 1, and the minimum required is 20 feet. The resulting impervious surface will be 22.5% of the total lot 1 area, and the maximum permitted is 15%. The proposed lots are 12,000 and 12,600 square feet, and the minimum required is 80,000 square feet. The proposed width of lot 2 is 120 feet, and the minimum required is 175 feet. The proposed front yard setback of lot 2 is 30 feet, and the minimum required is 60 feet. The proposed rear yard setback of lot 2 is 30 feet, and the minimum required is 75 feet. The proposed side yard setback of lot 2 is 25 feet, and the minimum required is 30 feet. And the proposed combined side yard of lot 2 is 50 feet, and the minimum required is 65 feet.
All right, you kindly raise your right hand, you swear to tell the truth, nothing but the truth, so help you God. Kindly state your name and your address.
Pete Ifkovitz, 81 Beach Road, Whitting Road.
You got the floor.
So we own the property at 81 Beach Road, which also abuts Herrick Point, the road directly behind us. We would like to subdivide or unmerge that parcel to have two pretty much equally sized parcel, one on Herrick Point, one on Beach Road. We feel like, the two resulting lots are in step with the character of the neighborhood. They're actually on the larger side of most of the lots that are surrounding us.
Anything's on the larger side down there.
Yeah.
Okay, question.
Sure.
Have you applied to the planning board?
Yes, we had the meeting with the public hearing with the planning board last week.
How'd it go?
Very well, very quick, there was nobody here.
Did they have a report?
They said that their report would be pending this year.
I see. So,
You get any report from planning?
Just, I was there.
no report.
They're waiting on this.
Oh, they're waiting on
So
us?
the board is aware that you're trying to do, and did you apply as a merger or a subdivision?
So we applied as an unmerger, but, as far as I could see, the application, everything was the same, it kinda said subdivision / unmerger.
So, did you own both lots at the same time? Did you take them under the same deed? Did you?
We did, yes, we did not merge the lots when we purchased the property, it was.
So you bought it as it is, as it was, as one piece, but on two different streets?
Yes.
Okay. And the people that had it before that was also in that same position?
Yes.
I take it?
Yes.
Okay. So with these variances, we have a large amount of variances to consider, but I think that if the planning board's comfortable with it, I would think we're comfortable, but I'm only speaking for myself.
Yeah, planning didn't give us any, update, you know, as much as they said they were going to you. I don't think any of us have any problems with it. We just need the okay from them, and I wish we had,
So I'd like to know what they're thinking and what their thoughts are. So, I was gonna suggest we get some kind of preliminary notes from them as far as how, cause there's gonna be some kind of a brief written by the planning board attorney. Which I think that Gail is gonna wanna have something to say about it. He's very familiar with the unmerger section of the code.
so,
You want something from Dick?
Excuse me?
You want something from Dick?
Yes.
I don't see a problem, but we just need to get the okay from the planning. Unfortunately, they didn't give us anything. Okay, so we're gonna adjourn you to the next meeting, which is the 28th, and,
You're on the docket.
So I should come to next meeting?
Yes.
Yeah, okay, sorry about
But you
that.
need to push the fact that we need something from them so that we understand that they're on the same page we are.
Right, so I
They
should,
may not even approve this, I don't know.
right. Well, I can say at the end of the meeting, they were on the verge of approving, and Greg said we should go through zoning first, so.
I see.
okay, well,
Okay,
we'll
that's-
comply with
No,
that.
that's fine, okay.
That gave me comfort.
Yeah, yeah. So,
Yeah, we're
should
just
I
gonna
reach out to planning and put a little pressure on them to get something to you guys?
We will do that.
Okay.
Even if it's Greg, Greg writes a memo to us and says,
Okay.
planning board wants to adopt it, however it is, and let it go to you first, there's something from him.
Right.
Or Dick Ellis, I'd probably be quicker through Greg.
Okay.
So maybe you need to speak with him and Carissa.
That's fine, I can send an email tomorrow.
You can scan and email it to us if you get something out of it, Carissa.
Yeah.
Thank you.
then just as a question of protocol, to come to the meeting next time, do I
You
do
know,
the letters?
you know
and
what you
the
do, why don't you call ahead of time, if we have any problems,
Well, just see if the report's coming, that's.
right, we'll get the reports, we'll check in with Clarissa a couple days before the meeting,
sign? Okay,
and, see if you have to show or if you don't have to show.
okay,
Okay?
all
So we're
right,
looking at 6:28?
6:28.
Yes.
I move that appeal number 18-29 be adjourned to the June 28th, 2018 meeting.
Second.
Mr. Seabrook.
Aye.
Mr. Barnes.
Aye.
Ms. Worthington.
Aye.
I vote aye. So
Thank you.
thanks very much for coming, thanks for putting up with the time.
Thank you. Yeah, that's.
Take good care. Okay, let's hear a motion, all signatures.
It's a shame we can't reach out to them and tell them to just go to the
We will,
ARB first
We
before
will.
they come here.
we will.
So we wanna, adjourn this till when? The first or
Next.
second meeting of July?
Next meeting,
Next meeting of June, which is June 28th?
28th.
Mr. Chairman, I move that, where are we here? Appeal number 2018-026 be adjourned to June 28th.
Second.
Mr. Barnes.
Aye.
Ms. Worthington.
Aye.
Mr. Seabrook.
Aye?
I vote aye. So we'll see them on the 28th. Do we hear a motion to accept the minutes from the last meeting?
So moved?
All in favor?
Aye.
Do we hear a motion to adjourn?
So moved?
All in favor?
Aye.
Thank you very much.
Thank you very much.
Thank you, Larry. You can cut us off.